Investigation, a train crash, a bus accident, and a little-known law that can derail the lives of unsuspecting commuters. Tonight's special report, No Accident, is next. In tonight's Target 5, a CTA accident. They're at fault, but you end up paying. How can this happen? Lisa Parker reveals the little-known Illinois law that some say can double the pain of CTA accident victims. Lisa?
And Allison, at issue here is an old Illinois law written back in 1945 as a way to originally protect the CTA from fraudulent lawsuits. Decades later, a question. Is that same law now also being used to shield the CTA from paying claims of legitimate accident victims? In a double right turn only lane at rush hour, a car on the left, a CTA bus on the right. The driver of the car took the turn.
I never questioned it.
The driver of the bus did not.
He had no intention of turning. I just wish I had known.
The police report from that day confirms the CTA bus in a right turn only lane went straight instead and hit the car of Merle Huckabee.
Oh my God.
Who was 6 months pregnant at the time.
I know it's the day that everything changed for me. An antidepressant.
12 years later, Huckabee says she still suffers from the injuries.
Help me up. Oh, okay.
And the medical bills related to that accident, but never recovered a penny from the CTA.
We had to file bankruptcy, and because the money to cover all the surgeries, all my medical bills, we just did not have it.
What stood between her and compensation was one mistake on the written notice required by law of anyone who claims a CTA-related injury. Deep inside Illinois' Metropolitan Transit Authority Act lies Section 41, which demands precise details about an incident. One mistake and the case shall be dismissed and the person forever barred from further suing.
It's a piece of legislation that's set up to victimize victims.
In Huckabee's case, the mistake was a missing address for the hospital doctor. Because of that, CTA lawyers went to court and triggered Section 41. Huckabee's case was dismissed forever.
That's the way Section 41 is designed, is to make it appear like things never happened off of a technicality.
The Huckabee case is by no means an isolated one. Target 5 reviewed dozens of Section 41 cases, some where one mistake, something as simple as a wrong street name or a missing address, over and over, got the claims of accident victims thrown out of court. Take the case of a passenger involved in this 2001 CTA crash where more than 100 went to the hospital. Dozens filed claims. One who did submitted the accident location as a southbound brown CTA line in Chicago, Illinois. Though the CTA never disputed she was on that train, it argued her description was not specific enough. The CTA clearly already knew where that accident occurred, but according to Section 41 case law, actual knowledge of an accident by the CTA does not matter. Her case was tossed out.
And I heard some boom, bam, boom, bam.
Annette Hargrove learned about Section 41.
What he said, you know, say that's a buzz.
After a CTA bus rolled backwards, reportedly unattended, down this hill at St. Lawrence and 95th and hit the car she was sitting in.
Oh my God, is my mother okay? Some guy said, well, don't move. What happened? What's going on? You might be hurt. I just see the bus. I don't see my car.
Though the CTA did not deny damage to the car its bus hit, Hargrove says it did deny her a day in court because of 3 details missing from her complaint.
You tell them that, they don't believe it. You know, oh, that couldn't be happening like that, you know. But it did.
Documented accidents on buses, inside trains, out in traffic, followed by slight reporting errors. Cases dismissed from courts forever.
It's not fair that the CTA can save a few dollars on the shoulders of people who have been really devastated by these things.
Attorneys who've worked on these cases say the Section 41 law routinely spits out claims of legitimate victims.
It's beyond extreme. There are circumstances where the information is totally useless to the CTA, and yet if you give it to them or give it to them mistakenly, it'll wipe out the case.
In some cases, judges have questioned the fairness of this strict compliance law, but reluctantly, as one put it, upheld it.
It's a cop-out. It should be changed by the legislature, but the courts are not powerless.
The CTA chose not to answer any of our specific questions on this law, but in a statement said Section 41 is a valuable tool that helps protect taxpayer funds and clearly states what type of information is required. CTA is a target for numerous claims, they say, and this law helps combat fraudulent ones. Those who advocate a change in this law say one word would do the trick, from strict compliance to substantial compliance, which they say would keep the legitimate victims in court at least to have their say and argue their case and still help CTA get rid of the bogus ones.
It's not just an argument of semantics, but it could, that one word could change everything.
One mistake, and we saw that over and over.
All right. Thank you.
You're very welcome.